Cuauhtémoc García Hernández, and it is my pleasure to welcome all of you to Tort Law Comes to Immigration Advocacy, the first event, the very first event of a new series at Ohio State University called Charlas on Migration. I'm a professor at the Ohio State University College of Law, where I hold the Gregory Williams Chair in Civil Rights and Civil Liberties. And it's my immense pleasure to host these charlas on migration. Today, I have the honor of welcoming Angélica Salceda, the Director of Democracy and Civic Engagement at the ACLU of Northern California, alongside Norma Ventura, a staff attorney at the Southern Poverty Law Center. Later this hour, you will have the opportunity to ask questions of both of them. To do that, please use the Q&A function in Zoom that should appear at the bottom of your Zoom screen, and I'll be monitoring that and bringing questions to the attention of our two gracious panelists. Today's conversation is the first of 3 charlas on migration that are scheduled for this fall semester. Next week on November 9th. I will host the second event in this series called Tracking ICE Surveillance, featuring 2 policy advocates who are steeped in the Immigration and Customs Enforcement Agency's use of advanced technologies to surveil people. And on December 7, I will host the final talk of the semester, chronicling Arizona's immigration politics, which is a conversation with the authors of a new book about Joe Arpaio, the well-known former sheriff in Arizona. Like this event today, those 2 will also be free. It'll be open to the public and it'll be accessible virtually. You are required, as you were today, you are required to register. So I will share the registration page information through the chat feature later this hour. Please feel free to use it yourselves, but also to share it with others who might be interested. Now, today I've asked Angélica and Norma to join us to talk about their work as lawyers who adapted old legal principles to challenge modern policy developments. At its most basic, tort law provides a legal remedy for personal injuries that one person suffers due to the actions of another. At its most aspirational, tort law returns the injured person to the condition that they were in before being injured. In the words commonly used, tort law seeks to make the victim whole. But lawyers and magicians, skilled though they are lawyers and judges, skilled as they are not actually magicians. Magicians are, though, also quite skilled. And tort law, as a result, tort law simply cannot rewind time. It cannot put us back to a position before an injury was suffered. A child can be returned to a parent, but a child can never be untaken. A child can receive medical and psychological treatment for abuse, but the abuse can never be undone. In recent years, immigration policies in the United States have resulted in these injuries and more. For a time, the federal government decided that it would take children from their parents. And to this day, children who are apprehended by Border Patrol agents are sometimes held inside holding facilities at Border Patrol stations. There, they sometimes suffer abuse at the hands of the very people who are charged with promoting not only public safety, but also their individual safety. Alongside a small number of other advocates, Angélica Salceda and Norma Ventura embraced an innovative legal strategy. New policies, they thought, might be susceptible to old laws intended to capture evolving community mores. The Federal Tort Claims Act sometimes imposes liability on government officials who violate the physical or emotional well-being of private individuals. Perhaps in taking children from their parents, these common law principles might run afoul of common decency. Morality has a place in the law, but there is not one version of morality. Instead of being unidimensional, judicial outcomes are the result of a multipolar tug of war between competing visions of justice. The cry of a distraught teenager is weighed against the centuries-old desire to immunize government officials. Full of trauma and full of fear, immigration policy is a complex story, full of promises of redress and obstacles to litigation. Tort law is a complicated web. Now, to help us reflect on how this complex story interacts with this complicated web, I am excited to be joined by Angélica, Salceda, and Norma, Ventura. I will begin by posing a few questions to each of them. And while we talk, let me again invite you to type your questions into the Q&A feature, which I will be monitoring. So with that, Norma, let me start with you. You were part of a team of lawyers that brought a lawsuit on behalf of 6 fathers and their children affected by the Trump administration's very well publicized policy of separating parents from their children. These were individuals who arrived in the United States in late 2017 and the spring of 2018. Those were the days when the family separation policy was in full force along the southwestern United States. And when the world was watching, I was living in Central Europe at the time, and I recall the nonstop news coverage there of what was happening in places like my hometown, McAllen, Texas. In those days, in those months and weeks, lawyers brought a variety of legal challenges to the family separation policy, some of which are ongoing. But yours was slightly different. You did not turn to the federal constitution. Instead, you turned to the centuries-old legal doctrine of negligence, as well as other types of claims grounded in tort law. And negligence is the stuff of first-year law school classes. And indeed, my students are immersed in it right now. So, Norma, tell us about the legal claim that you and your colleagues brought against the family separation policy and why you decided that tort law might be a good way of helping these families.
Sure, thank you for the question. So as part of a larger effort to challenge the Trump administration's draconian apprehension and detention practices, the Southern Poverty Law Center's Immigrant Justice Project, which is the project I work for, sought to file suit to seek damages as a result of the harms that the family separation policy inflicted on children and their parents. And as you stated, César, the Federal Tort Claims Act, or the FTCA, allows private parties to sue the United States in federal court for most torts committed by a person acting on behalf of the United States government. Section 1346B of the FTCA requires that 6 elements be met in order for liability to be imposed on the US government and for sovereign immunity to be waived, right? So the claim must be for money damages. It must arise from injury, loss of property, or death. It must be caused by the negligent act or wrongful act or omission of a federal employee. And that federal employee must be acting within the scope of her employment. And finally, the circumstances are such that the US, if the US was a private entity, it would be subjected to the imposition of liability under the law of the place where the tortious, negligent act or omission occurred. So all of those elements must be met in order for a party to be able to bring an FTCA claim and for the government's sovereign immunity to be waived. So essentially the FTCA renders the United States liable for compensatory damages in tort where state law would impose liability against a private individual under similar circumstances. So, just to elaborate a little bit more on that, the viability of each tort depends on the state law that controls. So the FTCA more or less is a vehicle through which the United States may be subject to suit, but it doesn't necessarily provide the substantive law underlying the cause of action. So that's where you look at state law, right? And as I'm sure you all are learning, different states have different laws applying to different torts, and the availability of torts may be, of a certain tort may be available in one state, but not the other. And so that's all part of what you're thinking about when you are trying to figure out where you're going to file your lawsuit. So, and then with the FTCA, there's an administrative exhaustion requirement. So claimants must first file administrative claims with the relevant agency and give that agency a chance to investigate and settle the claim. If the agency does not dispose of the claim within 6 months after the administrative complaint is filed, then the claimant can treat that non-response as a constructive denial and file her claim in federal court. So those are all steps we took for our clients, for example, where we filed administrative claims, and then once the 6 months passed and we got no response for any of those, then we went to court. So in 2 separate lawsuits, the SPLC filed, SPLC along with pro bono attorneys filed FTCA claims on behalf of a total of 7 fathers and 7 children, some of whom had been deported to their countries of origin, in this case, Guatemala. The suits were against the United States government for the torts committed by employees of the US Department of Homeland Security, whose custom and border protection agents carried out the initial separation and detained the fathers for extended periods. The US Department of Health and Human Services, whose Office of Refugee Resettlement, or ORR, detained the children. The Department of Justice and the Office of the Attorney General within the DOJ. And in the FTCA action, the torts that we asserted were negligence, intentional infliction of emotional distress, and loss of child's consortium, which is one that's specific to Arizona state law, which is where we filed.
Great, thanks so much for that overview of the way the particular legal avenue operates, the FTCA, and in particular the Federal Tort Claims Act, and how you tap the substantive law that's available in a particular jurisdiction, a particular state, to craft the pathway that you and your colleagues sought to navigate in order to obtain a remedy for your clients. I want to turn to Angélica now and talk a little bit about and build off of your Norma's comments about the differences from one jurisdiction to another that occur, that are relevant, of course, to an area of law like tort law, which is primarily not governed by federal law but governed by state law. But to think about a different aspect of that diversity that exists within the the United States, and specifically the politics of different jurisdictions. So the case that I've asked you to join us to talk about actually goes back further in time than the one that Norma was sharing with us. So in December of 2016, two sisters, one was 19 years old and the other was 17 years old at that time, left Guatemala to travel to the United States. When they got here, they were apprehended by the Border Patrol and they were taken to a Border Patrol station. There, they were sexually assaulted by a Border Patrol agent. Now, your clients, Norma, were affected by what was happening under President Trump, but what happened to your client, Angélica, took place while President Obama was in the White House. So as a lawyer, does the political climate affect the legal work that you do on behalf of your clients?
Yeah, so first, thank you for the invitation, and it's a pleasure to talk and share some of the lessons learned from this case. I will say that political climate had a significant impact on our approach to the case and also the reasons for the strategies that we employed around the case. The incident did happen under the Obama administration, but it was also on the heels of a presidential campaign, and it was on the heels of a lot of statements that at the time, then candidate Trump was making about the Border Patrol, and so it was statements about increasing Border Patrol. We knew that there were already existing human rights abuses at the border, including verbal and physical abuse, racial profiling, cross-border shootings. And so it was right before the election happened, but then obviously it also changed our analysis when President Trump came into office, because there was sort of a doubling down on the funding of Border Patrol. And then you had even comments from like White House Press Secretary Sean Spicer at the time, indicating that they wanted to take the shackles off federal immigration officers. So the incident that triggered our filing of an FTCA and a Bivens claim, because we added a Bivens claim there, we thought it was going to be important to just, as a way to highlight and illustrate the gravity of what was happening at the border and what could continue to happen with the increase of Border Patrol. And so we also wanted at the time, so we've also been working on a lot of advocacy to make sure that different complaints are actually reported, to the extent that there are complaints. And we know that there's complaints that are being lodged against Border Patrol and CBP all the time. There's just no adequate reporting of those. So there's just a lot of different issues that we thought that this case would be able to illustrate about the importance of instituting very specific reforms. And one of them, for example, is even the fact that for CBP detention facilities, they don't specifically have to comply with the Prison Rape Elimination Act, which we know like prisons and prisons have to. So there was all of these different elements that for us was important and could contribute to not just a change or relief in this specific case, but just larger changes to the system that we were currently at the time advocating for. So that certainly impacted given the limitations in the law, we thought it was also important to highlight this in the media, in our advocacy campaigns, because even if the law wasn't, we weren't sure how the case was going to shake out, but we thought that there was an opportunity here where the media could also pick it up, where we could also use it as an example in our advocacy, to potentially spur change. And another example where I think this case, we were able to use this case in an existing advocacy campaign was that we were advocating to the office of the Inspector General, the OIG, who had been looking at this case and had done an internal investigation. We were advocating that they actually had the authority to be able to provide certification for a U visa. We did not have at the time examples of OIG being able to do that, but because our clients had helped with an OIG investigation that had been underway when the incident happened, we were sort of doing that advocacy at the at the administrative level. And so then when it came to our clients through their immigration attorneys to go to OIG for their certification of their U visa, they actually were able to get it through the OIG. And since then we've gotten a lot of different questions from folks who are thinking of similar tactics. But even though it was a very difficult political climate with so much of the at the time, the president really talking about increasing the Border Patrol presence and the number of Border Patrol officers, we just ended up using the case as an opportunity to highlight all of the different issues that were going on and to also spur some changes in advocacy that we were engaging in.
So if I'm hearing you correctly, Angélica, the lawsuit is one of many aspects of the advocacy that the ACLU of Northern California, sorry, not Northern Colorado, Northern California was engaged in alongside with the partners. Some of it was trying to sort of shift policy within the Office of Inspector General. The U visa, just for those folks who are listening who are not familiar with immigration laws, and the existing feature of immigration law that provides visas to some people based on having experienced suffered been victimized of crime, of some crimes, and it sounds like there was a multi-pronged advocacy approach, of which this lawsuit was just one strand. Is that right?
Yeah, that's exactly right. And at the time, we also had been our Border Patrol project had been working on this large report related to complaints in CBP facilities that were holding children. And so we knew that that report was also going to be coming out and was pretty damning. And so even though that report was still getting put together, we thought this was another important aspect of that really illustrated with specifics and facts of what some of those incidents were that occur in these facilities with this very troubling agency.
All right, so let me turn back to Norma. So we just heard about this multi-pronged strategy, but part of what Angélica her comments illustrated was that there's a lot going on in 2016, 2017, 2018, transition from one administration to another. That was true of many areas of law. but immigration law and policy were absolutely no exception to that. So what motivated the FTLC to challenge the administration's family separation policy specifically, given the many possible realms to direct what are limited resources that you all have available?
Yeah, so during the height of the family separation policy, many of the separated parents were sent to detention facilities in the South. So, you know, folks may know that in the South, we have a huge number of detention facilities that are sort of like situated in these very rural areas, not by coincidence, right? Like, you know, maybe that's another conversation, but we at SPLC have a separate project. It's part of the project I work for, but it's called the Southeast Immigrant Freedom Initiative. And that initiative serves detainees at these facilities. So, you know, staff in that project began noticing a trend among a lot of detainees coming in May, June of 2018, with parents who had traveled to the US with their children, but had no idea where the children were and had no idea why the children had been taken from them. So as soon as, you know, we became aware of this trend, SPLC staff and resources were allocated to advocate for the release of the parents and then for the reunification with their children. And, you know, we soon learned that even after reunification, right, that the parents and children were experiencing severe trauma and had very little access to support services or treatment. Moreover, for these families, it was critical that the US government be deterred from ever engaging in such unconscionable policies, and that it be held accountable for the cruel, forceful separation of young children from their parents without plan to reunite them. So, you know, it really started out of our staff in CFE, that's the acronym for the initiative, noticing a trend amongst the recent detainees at these detention facilities, and then tracing it back to this policy that the government had enacted, you know, at least initially, very much on the secrecy side of things, and then went more public about it as part of, you know, their effort to deter asylum seekers from coming to the US.
You mentioned the lack of a plan. I want to return to the actual planning that is happening right now in the last few months in a few minutes. But before we get to that, Norma, let me turn back to Angélica and get a little bit more of a sense of some of the details of these claims that that you all have both made on behalf of your clients. So when I think of lawsuits against the federal government for injuries that people suffer, I immediately think of the government's traditional immunity from liability. And I alluded to that in my opening remarks. So can you tell us a little bit about how federal law immunizes the government and why you and your colleagues thought your clients might have a path around that?
Yeah, so I know Norma already touched a little bit on FTCA and government immunity, but so I'll just, the things I'll add is that there is a waiver of sovereign immunity embedded within the FTCA that extends to acts or omissions of law enforcement officers that arise within the scope of their employment, regardless of whether they're engaged in investigative or law enforcement activity. So to be able to hook onto that waiver, you look to state tort law to determine whether an employee is acting within scope of employment when they are committing the tort or when they committed the tort. And so at least in our case, our argument was that the CBP officer in question committed the tortious act. He was acting within scope of his employment. He was at the time he had detained our clients. Our clients were in the CBP field office. I will say that the tricky thing in our case was that although our clients, we were able to sue in the Eastern District of California in California federal court, we were able to do that because our clients were living in Fresno at the time. But the act occurred in Texas, and because the act occurred in Texas, we had to apply Texas tort law, which, as you all can probably guess, is not going to be as good as what we have in California. But you know, the FTCA does provide that waiver if you meet those elements, and we were able to argue that we met those elements. I think, again, the tricky thing is that in Texas, that Texas courts have frequently found that an employee committing an assault or battery has acted outside of the scope of his or her employment and not in furtherance of the business. So even though someone, and there's like some really egregious cases of like, you know, clearly doctors who are in their doctor uniform and just engage in some atrocious acts. Texas courts have found that that is not, even though they were performing an examination, for example, during the course of their business, that was not within the scope of employment. And so we were having to really grapple with some of that very difficult tort law. We were not deterred by that, but that was something that we were just having to navigate. Part of the waiving of sovereign immunity is also specific to claims arising from 6 intentional torts. And that really helps inform whether you can use the FTCA, because those 6 intentional torts include assault, battery, false imprisonment. The claims in our FTCA were for assault, battery. We included false imprisonment as well. So those are also additional elements that you just have to consider whether you have those in your case to figure out whether you would be able to bring in FTCA and not have to deal with the sovereign immunity piece.
Right. So so let me get back to return to this comment that Norma made earlier about, you know, one of the reasons to target the family separation policy was in part it's on like a desire to get some relief, a remedy for having experienced a traumatic event where the government really had no plan for figuring out what to do after separating parents from their kids. So in recent months, the Biden administration has set up a task force to address exactly what you're describing, Norma, the fallout from the Trump administration's family separation practice. So is the administration taking steps, is the Biden administration taking steps to help people like the families that you represent?
So, you know, my understanding, or our understanding of this, the Biden administration's family reunification task force, is that their primary purpose is to reunify the families that remain separated. So, folks may recall that I think during the summer, there were like news stories about 500 or so families who remained separated, and that the government was either saying that they've lost track of the parents, or they lost track of, which child belonged to who. And so the primary purpose of that task force was really to reunify, find the parents, find the kids, and make a reunification possible. In many instances, the children remained in the U.S. and the parents were in their country of origin. And so a lot of the work involved tracking families, wherever they were. For us, thankfully, the families we represent in our lawsuits were all reunified back in 2018. And the duration of separation varied amongst them from like 3 to 4 weeks to almost 8 months. But they were all reunified in 2018. Recognizing that the family reunification for the families that remain separated should be prioritized. Of course, we hope that the task force also engages in meaningful efforts to provide support services for families impacted by the family separation policy. So, the services range from access to mental health services for the parent, the child, but really the entire family unit, to actual immigration relief, right? A lot of parents were pressured into agreeing to deportation on false promises that they would see their children, either, on the airplane that was going to take them back home, or shortly after they would return to the country of origin, they would get their children back. So, the relief that needs to come to these parents after reunification needs to be vast, right? Because the trauma that they experience from the separation has been so severe, right? We're working with experts for our cases who are of the opinion that for some of these children, the extent of the damage was so extensive that we're talking about like changes in brain structure, right? Like in development that may affect the children for their entire lives. And so, reunifying the families that remain separated, of course, should be a priority, but it's a long road ahead, I think, for this task force, if it is to make real efforts to repair some of the damage that has been caused on these families.
And I'll also add there was some recent reporting done, I think I want to say in the last week or so, about the possibility of a financial payment that the federal government is contemplating. Now, there's, as far as I know, none of that is public, and it seems to have been based on the reportings, based on some conversations with some people who are knowledgeable about what's going on within the task force's operations. But it'll be interesting to see whether or not a financial compensation scheme is agreed upon, and what amounts are actually agreed to, because the services that you're describing, Norma, are well, they're not cheap, right? These are extremely expensive mental health and medical care expenses. Certainly, that's true if we're talking about an entire lifetime. So I know we have some questions that have already come in. I want to invite others to jot theirs in as well, and I'll turn to those in a minute or two. But before I do that, I do want to ask one final question of Angélica, and that's about a little bit about the settlements and sort of remedies, and identifying the suitable or agreeable resolution on behalf of clients in situations like these. I know your clients settled with the federal government, and I'm not going to ask you to disclose any of the details of that settlement that are protected, but can you share some of the considerations that you and your colleagues went over as you advised your client about whether they should settle?
Yeah, so there was a number of different factors playing in our case. One, there was a constant concern for us that the case could get kicked over to Texas. It occurred in Texas. We were also in the Eastern District in California, which is one of the most backlogged federal districts in the US. Judge Droz in the Eastern District in California recently even issued an order basically saying if your case is unassigned, it's going to be stayed for all the civil cases. So we just thought that if there was any possibility that the government could make an argument that this should be in Texas federal court, we really feared the possibility that any judge that we'd be assigned to would take that opportunity and just say, sure, take it over to, and that would be just logistically harder since I'm based in Fresno, our clients were based in Fresno at the time. And so that was one consideration. The other thing was, and I think this is important, and I know this happens a lot to all of us that are talking to clients, is just even explaining what settling would mean. And this was sort of a difficult conversation that we had to have with our clients, because in settling, there is this, the government is not admitting to any fault. And so then having to sort of explain that to your clients who were wronged and want to see a resolution here, and what does it mean to settle a case? And when you're settling, at the end of the day, the federal government is saying, like, we didn't do anything, we're just settling the case. And I think that was those were very difficult conversations to have, because of course people were wronged, our clients were wronged in this situation. So obviously our clients' considerations are the primary considerations in settling. I will say at some point in the case, there was so much media. We did local media, ABC 30, the 3030 segment ended up doing a report on this. There was a great story on NPR Radio Ambulante. There's a lot of media, to the point that like our clients were like, we're done. Like, we don't, like, it's really hard for us to keep on talking about this over and over and over. And sort of recognizing that if we continued moving forward, and this is something, that sort of we recognize, is that they would have to continue talking about this over and over. So there were just a number of different things that we talked with our clients and that we weighed in deciding to settle. And obviously at the end of the day, the monetary amount that was offered, which was our client's decision, whether that was something that that they would accept. So
Angélica, let me follow up on that with one of the questions that we received from the attendees. So, given all of the various considerations that you just talked about, one of the questions is asking about a different factor that you mentioned earlier in response to one of my questions about the political climate. So the question is, given that your legal strategy was influenced by the country's political environment, would your strategy change, and how would it change if it happened in the middle of the Trump administration or even now during the Biden administration?
I don't think our strategy would have changed from then to now. We still see that there's abuses by Border Patrol. I don't think that that's going to change unless there's real reforms on those agencies. In those specific cases, sometimes it is a strategy of like who is on the other side, who is the AUSA that you're dealing with, what are their priorities, are they going to be more open and reasonable to negotiating. So I guess, you know, to that extent there are some considerations, but I personally don't think that there's been much of a change since the Trump administration to now the Biden administration that would change how, like, our strategy. I think that there's still a lot of advocacy that is happening and that needs to continue to happen.
Okay. Thank you for that perspective. I wanna see if I can get Norma back into this conversation with a claim about the way that deportation intersects with the FTCA and the claims that you both of you have been talking about. So can the question asks, can people litigate their FTCA claims even after they have been deported, and what obstacles should be considered in bringing that kind of a claim?
Yeah, it's a really good question. And I think it was something that we took into consideration. As I mentioned, 3 of our plaintiff families are in Guatemala and have been in Guatemala since the beginning of the lawsuit, since we filed it. So, you know, we expected that the government would challenge venue in that, you know, arguing that the clients couldn't establish residence, the residence requirement. And so we were somewhat, you know, concerned about that. But in the government's motion to dismiss, it wasn't something that they raised. So we didn't actually have to brief it. But you know, to this day, it hasn't been challenged. So I do think it's an important consideration as you're thinking about where to file your lawsuit, right? And looking into the law for, you know, in whatever jurisdiction you might be, with in, you know, like the case law on any residence requirements. But you know, we were comfortable enough to file in Arizona. We had and you know, what's interesting is that all of our other plaintiffs, I believe, were in states other than Arizona. So, you know, for us, what was tying us to Arizona was that it was the area where all of our clients had entered. So they had entered at ports of entry, some of them in Arizona. And, and that's why we chose that venue. But the lawsuit is still in place, and it hasn't been challenged. So there's definitely opportunities to bring these cases, even if your client is not in the United States.
So let me ask a question of both of you, or either of you, that also comes in from somebody who's participating. So the FTCA allows you to challenge government policy as a whole, or simply the conduct of specific individual employees of the federal government, and do you see parallels between the way that the FTCA allows legal challenges against certain governmental activities in the immigration context, to those instances in which the other areas of law allow challenges to abuse by police officers and in the course of their own policing duties.
So I will just to clarify. So the FTCA is about tortious actions. Policies, at least in our case, came into place because one of the other defenses that the government can raise is the discretionary function, which is, did the officers have discretion, or did they have to, in our instance, we looked at a policy about that dictated how an officer has to conduct a strip search. So you look at the policy to say, this is what they should have done. They did not do it. So it, the claim can't be barred. There was a specific policy that was in place. They didn't follow it. And so they had no discretion. There's specific protocols that they should have followed. So it's I will say the FTCA is not perfect. It's often used when other avenues have been foreclosed. It's also used as a way to get your clients money to make them whole, as we think about torts law. But I think there are parallels there to the extent that we see a lot of FTCA claims are also coupled with Bivens claims, which are your constitutional claims that you would bring into a case. And in those Bivens cases, you have the traditional qualified immunity that you often see in a lot of those police cases. And Bivens cases with time have also become a lot more difficult, especially after the Ziegler versus Bossie case, where courts are just far more cautious about how far and what certain cases to extend Bivens claims. So certainly lots of limitations, but use in those situations where there's a specific act, you can look to tort law, or you can look to a constitutional right and be able to point at it. I think the policy considerations, those sometimes these cases are used to highlight the very, very bad policies that are in place and that we really need to change, either through impact litigation or advocacy.
Right. So thinking about one of the other questions asks you all to essentially to imagine, sort of take a step back from the particular clients, the particular people who you're representing, the particular litigation that you're bringing on their behalf, and view tort law more broadly, more generically. And specifically, the question asks, so what are the gaps that you see in tort law when working with these cases? And in what ways would you adapt tort law to better support the cases that you're involved in, if at all? And do you think that it's realistic that those kinds of evolutions in tort doctrine are possible?
I can chime in, and then Angélica, feel free to jump in. But you know, as with really any like law, you'll soon find out that most are imperfect, right? And most are really weren't created with the types of clients or communities Angélica and I probably represent, right? So you can imagine the challenges with you know, some of the burdens that these claims impose on our clients. And I think with tort law specifically, I think in what's tricky with the FTCA, which I kind of alluded to earlier on, is that you know, it's controlled so much by whatever state you end up in, right? And as Angélica mentioned earlier, if you're somewhere like Texas, like you're gonna have a really hard time, right? Overcoming some of the defenses available in a state like Texas. Whereas if you're in California or Arizona, you're probably a little better off. And so I think the challenges, for example, in the cases I saw was that we had a number of folks who, you know, families, parents who had reached out to us from places like Texas and, you know, other states where the tort law is just so unfavorable. And you know, and you're having to weigh whether, you know, whether you'll do more harm than good in bringing cases for folks in some of those states, right? And so just this lack of inconsistency across states, across circuits, in how these torts are applied and the defenses that are available really makes it challenging. And you know, and sort of the artificial lines that are drawn for relief for folks living in some states in comparison to states living in other states is really frustrating. So, you know, that's kind of my initial reaction to that question.
And if I could just chime in really quick, I mean, the other gap is obviously that for FTCA, you're limited to those claims that are specified in federal law. So assault, battery, false imprisonment, false arrest, malicious prosecution, abuse, you know, so if there is a tort that does not fall within that, and some of the other factors that you have to consider, then you can't use the FTCA. So I think those are other limitations that there's a lot of torts that happen, including negligence, for example, that just wouldn't be available under the FTCA.
Great. So on my sort of takeaways from this is the FDA certainly provides a valuable vehicle to try to redress some harms suffered in interactions with government officials at times. But of course, as is true of most areas of law, it is limited in what it can do, and as a result, sometimes you know, it has to be paired with other claims that might be brought either on behalf of the specific individuals or to challenge a policy, a government-wide policy, through a completely different legal mechanism. But of course, all of these legal theories are nothing more than theories until somebody is willing to actually bring them on behalf of a particular person or particular individuals. So I want to thank Angélica Salceda and Norma Ventura for joining us this afternoon to share some of their experience doing exactly that, not necessarily looking for the one legal theory that can vindicate all injuries, but on one that might help their specific clients move a little bit further down that direction, and to do so creatively and innovatively. With that, I want to thank both of you, Angélica and Norma, for joining us, and thank everyone who tuned in this afternoon. Again, I hope that those of you participating today will consider joining me next week on Tuesday, November 9th. When I'll be joined by Jacinta Gonzalez from Mi Gente and Nina Wang from Georgetown University to talk about the role of technology, advanced technologies in boosting the federal government's surveillance capabilities. And then in December to talk about some of the changes in the political climate in Arizona specifically. Thank you all very much for joining us. Thank you, Angélica, and thank you, Norma, and hope to see many of you next time.